I am not aware of those efforts, no.
Good afternoon. My name's Neil Sandage.
Okay,
We're listening to a live broadcast of the SCOTUS nomination. And I've been typing instead of
several times
breaking to speak to you. This is going to be kind of boring, but every time I type, it mutes the speech, so I have to record a video.
In Lawrence versus Texas, in support of state laws punishing private homosexual activity. They celebrated when India restored a law punishing sodomy to 10 years in prison. Now, I don't know whether you believe that being gay is right or wrong is irrelevant to me. But my concern is what you work with an organization working to criminalize people.
You don't really understand. You're not going to believe why someone gets angry about something. I'm typing again. I don't mean to be typing, but there are reporters who aren't in this. And I guess instant gratification, I should wait till the end of it to do all this. Because you can see the video and everything stopped, and I stopped hearing what's going on. And anyways. You'll never believe ever why people will get angry. It's actually population. Man, this sucks. I gotta stop typing and just talk to the camera if there's any comments. He more than gets the point, though.
But we're about a little over a minute over. So if you,
I am sorry, Mr. Chairman, I do not have a.
No, I understand. I totally understand.
I appreciate it, and I look forward to the next round of questioning.
Thank you. We'll make sure that happens. Very briefly, before we go to Senator Cornyn.
They're killing
Senator
all of them,
Lee
and they don't believe in pro-life.
Probably all of us on this side were consulted by the
Somebody's angry again.
He gave me a small list of names, all women. You were on it. I was enthusiastic about everybody. Very enthusiastic about your nomination by the president. Play a lot of golf with the president, I guess. I've enjoyed it. We talk about a lot on the golf course, some policy. Killing Soleimani, we talked about that. That was an interesting discussion. I promise you, I've never talked about severability with the president. Senator Cornyn, speak for yourself.
Good morning, Your Honor.
Good morning, Senator Cornyn.
You know, most of us have multiple notebooks and notes and books and things like that in front of us. Can you hold up what you've been referring to
I
in
do.
answering our questions?
I have this. Here's pages and pages of writing.
That letterhead that says
I had to
United
find a
States
new
Senate.
clear page to write on.
That's impressive. Well,
And,
Judge,
I got distracted, and I should be right here, so thank you.
the best I can understand, the objections to your nomination are not to your qualifications, your experience,
It's her
or
judgment.
training, but it's that you have or you will violate your oath of office.
She would need to.
I find that terribly insulting.
Right now, we're killing all of them, and she's trained to intermarry and do all sorts of wrong
They
things.
suggest that you can't be
And she withdrew from
unbiased
IVF. You have to fight for
in
IVF.
deciding a case you haven't even participated in yet. I find that insulting as well. You know, almost as pernicious as attacking somebody for their faith and suggesting that that disqualifies them from holding a public office is the attack that's being made on judicial independence, something that Chief Justice Rehnquist,
Well, it's
among
the
others,
attack being made on her
observed
also.
the
She
crown
claims to follow
jewels
canon, but in
of
the
the American
Bible, God
Constitution
came
and
to
the
her
American
and said
system.
she would have a child before she ever got pregnant.
But I want to
IVF is protected under the Bible.
Lane here. You know, there are a lot of people who guessed how judges would actually rule on cases, and almost always they've been spectacularly wrong. I was struck by just a couple. Harry Truman said, "Whenever you put a man," and that he's talking about a man, but a man or woman on the Supreme Court, he ceases to be your friend. He said some more colorful things too. But Theodore Roosevelt said about Oliver Wendell Holmes Jr., he said, "I could carve out of a banana a judge with more backbone than that." And as I think about people like Harry Blackmun, nominated by Richard Nixon, who wrote Roe versus Wade. As I think about Warren Berger, you know, they were called the Minnesota Twins, and obviously over time they became sort of polar opposites on the court.
The
I think
voice
about
of
the
God
attacks
is
on Neil
1909, controlling
for his
people's name
unwillingness
choosing. The 1960s proved through
previous
radar they
prior
could control the
commitment on
entire nation.
LGBT.
It actually started with weather radar
He
in
wrote the Bostock case,
54,
extending
57.
Title VII of the Civil Rights Act to gay or transgender individuals. Obviously, those predictions were wrong. And then, since we're talking about the ACA, it's the ACA versus ACB, I guess. Chief Justice Roberts was the one who wrote the opinion upholding the Affordable Care Act, as you know. So I would just say that
The
all of
Affordable
these
Care Act
predictions about how
had to
judges
protect information for
under our independent
life plus
judiciary
70 years.
will make
It limited
decisions
the medical information to 7
are
years. It
just
didn't
pure
increase it at all.
speculation. But I think they're worse than speculation.
When
think
they
they're
vote on
propaganda
things, they have to append
in order to try to
requirements
make
that
it
exist in
political.
other laws applying to this law also. And they're not doing that by
So,
just obeying the law,
Judge, you're not
They're
willing
not-
to make a deal.
applying comprehension of all the other
No,
laws.
Senator Cornyn, I'm not willing to make a deal, not with the committee, not with the president, not with anyone. I'm independent.
I just would like to hear maybe some of your thoughts on, in the Oberfeld case, which established, as you said, a constitutional right to same-sex marriage. Part of that decision struck down the Defense of Marriage Act, correct?
Yes, I believe so.
That was a bill that Joe Biden voted for.
I don't know
Well,
about that.
I do.
Okay.
Joe Biden voted for it, Pat Leahy, and Bill Clinton signed it into law. Can you just, I'm not asking you to get into the details, but just sort of differentiate for everybody listening what the approach of a legislator is in voting for a piece of legislation as opposed to the role of a judge in interpreting the constitutionality of a piece of legislation? Are they the same or are they different?
They're quite different. A judge isn't expressing a policy view. You know, I
There
tell
an
my
opinion.
students in constitutional law that
It is called an
newspapers
opinion.
do courts a disservice when, you know, they say things like, you know, court, favors same-sex marriage, or, just giving the headline without showing any of the reasoning that goes into it. Because courts are not just expressing a policy preference. They're digging in, they're looking at the precedent, they're looking at the Constitution, and even when the result cuts against policy preferences, judges are obliged to follow them. I suspect that this body doesn't cast votes that conflict with their policy preferences.
Well, that's right. And the difference between us and you is you don't run for election.
That's right.
You don't run on a platform. You don't say, if I'm confirmed, I'm going to do this or that. You don't do that, do you?
It would be wholly.
There should
wildly
be
inappropriate
judgments
for me to
that they
do so.
think are worth defending.
Well, your mentor,
There
Justice
should be
Scalia,
past
said
judgments
something
that they
back in
stand by,
2005 that I find intriguing.
or
but
previous judgments they
reassuring.
uphold as important.
He said, if you're going to be a good and
No
faithful
pride in
judge,
work sucks and should
you
not
have
be
to
hired.
resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. Do you agree with that? And if you do, would you explain what you mean?
That's the
I
reason they
do
allow
agree with
opinion
that,
is because you
and
can
that,
disagree
has
with
been my
making the right
experience
decision
on
or the
Seventh
legal
Circuit
decision.
So far.
You can
It's your
voice that
job
this needs to change
pass
so that the Senate
statutes.
and legislature
It's
can
your
change
job
it.
to choose policy. And then it's my job to interpret those laws and apply them to facts of particular cases. And they don't always lead me to results that I would reach if I were, queen of the world and I could say, you win, you lose, or this is how I want it to be, because I just don't have the power by fiat to impose my policy preferences or choose.
You
the
do. That's
result I
exactly what
prefer.
fiat
That's
is.
just not my role. I've got to go with what you guys have chosen.
And you have
Why
the
in
ability
world
to
would the
choose,
American people
but you can also just voice something in the
surrender their
record
right
to forward
to govern
to the
themselves
legislation
through their elected representatives?
Goddamn,
through the
hiring an
Constitution
empty
of nine
chair
people
instead of a
don't
human
even run for
being.
election and who serve for life. Why in the world should the American people do that?
Well, I think part of the rationale for courts adhering to the rule of law and for judges taking great care to avoid imposing their policy preferences is that it's inconsistent with democracy. Nobody wants to live in accord with the law of Amy. I'm sure my children don't even want to do that. So I can't, as a judge, get up on the bench and say, you're going to live by my policy preferences because I have life tenure and you can't kick me out if you don't like them.
That's not
Well,
at all
thankfully,
correct. And that is what I would do.
Under the Constitution,
But
even if
what I
the
would
Supreme
do
Court
is I would have a
strikes down a
factual
statute,
basis.
Congress
She
can come
stated
back
it
and
without
revisit
having any
that.
facts for it. The law of Amy
do
is the
so in a way
experience
that
of
doesn't
Amy
violate
and not her stupid mouth.
as determined by the court. And ultimately,
Because she
doesn't
didn't
happen very
validate
often
any of
in
the
our
things she
history, but
said. She
hopefully
just
we can
mocked
amend the
her
Constitution
existence and her
itself,
ability to
right?
make
That is
judgments,
correct.
calling it
So
the law of Amy.
the basis of legitimacy of
And
governmental
it's the law of
power
reality,
is
not the
consent
law
of
of
the
me.
governed. Do you agree with that?
I do agree with that.
Not what 9 people in black robes, the high 9 on the Potomac, I think they're sometimes called,
It should be
the
12.
decisions they make. That's not the final
And
word.
the
in our
Potomac is
form of
dead
government,
bodies
right?
in
We are
chairs.
a law. A
Whoever
government of
came up with that,
laws,
thank you for
not
citing
of
it.
men.
Well, Judge Barrett, I'm almost through, but I can't pass up the opportunity to ask you a question about the Establishment Clause. I did with Justice Kavanaugh and Justice Gorsuch as well. It's born out of my frustration. One of the couple of times I had a chance as Attorney General of Texas to argue before the Supreme Court, I argued in a case called Santa Fe Independent School District versus Doe. This was about a commonplace practice where before football games in Texas, students would volunteer to offer a invocation or an inspirational poem or saying or something like that. The ACLU sued the school district, and obviously it made its way all the way to the Supreme Court. And I'm not going to ask you your opinion on the outcome of the case, but what troubled me the most about that experience is when the Supreme Court struck down or held that practice unconstitutional and in violation of the Establishment Clause. Chief Justice Rehnquist said the Constitution requires neutrality toward religion, but the court's approach speaks of hostility toward religion. Could you just talk a little bit about the Establishment Clause generally, with not in regard to any particular set of facts, but sort of what the courts over time have tried to do to enforce the mandate of the Constitution?
Well, Senator Cornyn, when I interviewed for my job with Justice Scalia, he asked what area of the court's precedent that
They
I
should
thought,
require
needed to
original
be,
words and not
better organized
recitation.
or that sort of thing.
As long as it's original
And
words, I would encourage
Off the
it.
cuff, I said, well, gosh, the First Amendment. And he said, well, what do you mean?
But
And I
quoting the
fell down
Bible would be a
rabbit hole
sermon
of trying
and
to
would be a
explain
violation.
Without success, because it is a very complicated area of the law, how one might see one's way through the thicket of balancing the Establishment Clause against the Free Exercise Clause. It's a notoriously difficult area of the law. And to the extent that, there is tension in the court's cases, and I'm giving you no better an answer, I assure you, than I did to Justice
Just
Scalia that
original.
day.
You can talk about
It's
the
been
Bible,
something that the court
but it has to be
struggled
original
with,
words.
for decades to try to come to a sensible way
Not a
to
quote
apply both of those
or
clauses.
a canonization or
Well, I
whatever they
wish you
call it
well.
that the Catholics do.
Thank you, Senator.
Catechism. I was trying to say catechism.
Mr. Chairman, I'm going to reserve the rest of my time.
It has to be
Okay, Senator
living
Cornyn,
in the
for
Word. That's
planning
commanded in the
purposes,
Bible.
if it's okay with the committee.
God is alive in
I'll
me,
have Senator Durbin,
or the
Senator
living
Lee,
God
break,
in me.
For about a half hour for lunch and come back with Senator White.
I worship the living.
Okay.
I don't worship the
Senator
dead
Durbin.
recitations.
Are you okay with that? Do you need a break?
No, that's fine.
But also, that isn't what I would say. That isn't my
Thank you, Mr.
choice of
Chairman,
wording.
And thank you, Judge Barrett, and your family.
I do
for being
believe in
here with
living,
us today, for
but
this
I also honor traditions.
questioning.
It's just separating
Senator
things
Durbin.
from events. That way
I
people
would like to respond to my
don't
colleagues
think that
directly
there's
before
something
I
they're not.
ask a few questions.
Physical fitness is the
How-
Bible
who came
people
up with
and
this
not
notion,
the
this
new
insulting
Bible people, but
notion
the original
that you might violate
language.
your oath? Where could this idea have come from? Could it have come from the White House? Could it have come from the president's tweets of what he expects a Supreme Court nominee to do politically for him? That's where it comes from. That's where it originated. And you have said very clearly today, without equivocation, you are not going to be influenced by President Trump's importuning or the importuning of this committee or anyone else, which is what we expect you to say. But this notion that this whole idea of your being used for political purposes is
Yeah,
a Democratic creation.
To have sex with
Read
children.
the tweets, and you have plenty to work with.
Her name and the life she's lived.
The
Being in
second
a
thing
sex
I would like to
cult in
say is,
Indiana.
I'm not going to
She's
spend a lot
to
of time
destroy the
defending
future of any
the Affordable Care
future
Act,
Supreme
although I
Court
think it's
justice,
the most
just
important
as Brett
step forward
Kavanaugh
cast as
is there
member
to
of Congress,
destroy
period.
the future of all
But I
Supreme
will
Court
say that
justices.
when the chairman opened up on it, and
Teaching
said he
alcohol and
did, I was puzzled.
loose free
Three states
sex.
get 35% of the money. How can that possibly be true? Well, it turns out because those states decided to extend Medicaid coverage to the people who lived in the states, and his did not. And as
Amy
a consequence,
Coney,
fewer people in South
at the
Carolina have the
Barrettes or
protection of
Barrettes
health insurance.
is
And
a
those
staged
that do
pawn
are
telling
paying
all the smart
for
people
their
to give
services,
themselves away as
and
sex
those
toys
that don't are not,
and to let
which
their husbands or
barrels,
whomever
hospitals, and
have
others
turns
in
with their
the process.
children.
So I would say there is an
And she also
explanation
permits
as to why
abortion
some
of
states are
the
spending
babies
more
had from her
intensely.
children.
There was a Republican governor of your state, Indiana, by the name of Mike Pence, who decided to break with other Republican governors and extend Medicaid coverage under the Affordable Care Act. I think it was the right thing to do for Indiana as it was for Illinois. But that's part of the reasoning. Let me just say that the Affordable Care Act really is at the heart of this, as you can tell on the Democratic side. We really believe
It's
the
not about the
Supreme Court's
Affordable Care Act.
consideration
It's
of that
about the
case
record
is
keeping.
could literally
Right now,
change
you are seeing if you can
America
get rid of
from millions
everybody
people.
who has a legal
I have
record
with you today
and remove their right to medical coverage or the requirement that they continue medical coverage.
But,
And so these people are communicating something they want her to do and getting a promise from her that's implied rather than verbosely agreed.
Joey, Tommy, and Mikey. Matt, who's 27, was diagnosed with type 1 diabetes when he was 13. The other three Williams boys were all born with cystic fibrosis. Joey is 24, Mikey's 21. Sadly, Mikey's twin Tommy, after this picture was taken, passed away in January 2019.
Yeah, everybody
from
needs medical
complications.
coverage.
This is the last photo that was ever taken of their full family. Here's what they wrote me. We cannot imagine having to go through losing another child. People with cystic fibrosis require daily medication, regular doctor visits, access to high-quality specialized care. That means people with pre-existing conditions like cystic fibrosis cannot be discriminated against. The ACA's protections ensure a ban on annual and lifetime caps and enforce the requirement that insurers cover essential health benefits such as hospitalizations or mental health services. People with CF and other pre-existing conditions need adequate, affordable health care to live longer, healthier lives. That's why we keep bringing this up.
And to discover the cause of the illness.
All the time.
I agree with this, Mr. Dick Durbin.
On the Republican side, there's some obvious controversy as to whether we're right or wrong. But there are an awful lot of people in each of the states represented by our Republican senators who have their health care and literally, in some cases,
The challenge is paying for it, and that's the reason we need to do the computers, because people get influenced like me. Cognitive radar causes me to misspeak,
2 million living in that state.
and we need the ability to analyze the record and try and rescue people from becoming the next
Here's what it
Native
comes down to.
Americans.
You've been unequivocal
And
and
we still got
critical of the
Native
decisions,
Americans alive.
both in NFIB Sibelius and in King Burwell. And we naturally draw the conclusion there's going to be a third strike when it comes to Texas and California. You said it won't affect pre-existing conditions. If the petitioners have their way, there will not be an Affordable Care Act to protect pre-existing conditions on the severability question. So give us an insight how you can be so unequivocal in opposing the majority decisions in NFIB Sibelius and in King and Burwell, but have an open mind when it comes to the future of the Affordable Care Act.
Sure. Thank you for that question, Senator Durbin, because it gives me an opportunity to make my position clear. When I wrote, and this was as a law professor, about those decisions, I did critique the statutory interpretation of the majority opinions. And as I've mentioned before, my description of them was consistent with the way that Chief Justice Roberts described the statutory question. But I think that your concern is that because I critiqued the statutory reasoning, that I'm hostile to the ACA, and that because I'm hostile to the ACA, that I would decide a case a particular way. And I assure you that I am not. I'm not hostile to the ACA. I'm not hostile to any statute that you pass. And the cases on which I commented, and we can talk at another time, I guess, about the context, the distinctions between academic writing and judicial decision-making, but those were on entirely different issues. So to assume that because
Not really.
I critiqued the interpretation of the mandate
It's called
or the phrase
comprehension.
established by a state
Logic
means that on the
bridges from
entirely
one place
different
to
legal
another.
question of severability, I would reach a particular result, just assumes that I'm hostile. And that's not the case. I apply the law, I follow the law, you make the policy.
I would hope
So
that Dick
let's
Durbin
talk
just
about that for a
educated her
moment
and
from a
changed her
different issue
position.
perspective. Bear with me for a couple questions. Have you seen the George Floyd video?
I have.
What impact did it have on you?
Senator, as you might imagine.
Confusion.
given that I have
It was
two
black
black
hair
children,
who killed
that
him,
was
and black
very,
eyebrows who killed
Very
him.
personal for my family.
Why would they do that
Jesse
to a
was
cousin?
with the boys on a camping trip out in South Dakota. So I was there, and my 17-year-old daughter, Vivian, who's adopted from Haiti. All of this was erupting.
Only
It was
foster,
very
never
difficult for
adopt.
her.
If they're a different
we wept
race or
together
genetics.
in my room. And then it was also difficult for my daughter, Juliet, who's 10.
You can only
I had to
adopt
try to
what is actually
explain some
blood
of this
family.
to them. I mean, my children to this point in their lives have had the benefit of growing up in a cocoon where they have not yet experienced hatred or violence. And for Vivian, you know, to understand that there would be a risk to her brother or the son she might have one
Yeah,
day.
they're not allowed to take on your
that
family name
kind of
either. They're trying to
brutality
restore their original
has been
family
an
name.
ongoing conversation. It's a difficult one for us, like it is for Americans all over the country.
And so I'd like to ask you, as an originalist who obviously has a passion for history, I can't imagine that you can separate the two, to reflect on the history of this country. Where are we today when it comes to the issue of race? Some argue it's fine. Everything's fine, and you don't have to even teach children about the history of slavery or discrimination. Others say there's implicit bias in so many aspects of American life that we have to be very candid about and address. Others go further and say, no, it's systemic racism that's built into America, and we have to be much more pointed in our addressing it. How do you feel?
I feel
So,
that we need to talk
think
about
it is
genetics and no longer
An
racism.
entirely uncontroversial
And that we must
obvious
use
statement,
National Institute
given,
of
as we
Health
just talked about, the George Floyd
categorizations
video,
and
that
increase the
racism persists
diversity
in our
of
country.
recognition
As
rather
to
than say
putting
we
my
only need
finger
white
on
and
the
black
nature
as
of
if
the
that's a real
problem,
color
whether,
for
as you
an
say,
organic
it's
creature to
just
be.
outright or
That guy back
systemic
there is
racism,
brown. That
or
woman
haven't
is some sort of
tackled
pink
the
tan.
the issue of making it better.
And she's got good eyebrows,
things,
which no
you
white
know,
person has.
are policy questions. They're hotly contested policy questions.
It's not contested.
That have
It's
been
just a
in
fact
the
of
news
reality.
and discussed all summer.
Your medical record
while,
is your species.
As I did share my
Rather than
personal
using race,
experience,
which is
very,
penis or
you know,
water
happy
channel
to
or
discuss
vagina
the reaction
channel,
our family had
we
with
need
the
to
George
become a
Floyd video,
species.
giving broader statements or making, broader diagnoses.
Because right now,
about
all of it is a sexual
the problem
attack on the
racism
children.
is kind of beyond
That's what race means.
what I'm capable of doing as a judge.
Vagina and penis,
Well,
water channel.
I would doubt that. I just don't believe you can be as passionate about originalism and the history behind language that we've had for decades, if not centuries, without having some thought about where we stand today. But I'm not going to press you on that. I'm going to take you to a case which I have read and reread, Cantor versus Barr. You know the case well because it's already been referred to. And it clearly is a case where you had your day in court. You wrote the sole dissent, in a 64-page case, 37 pages were your dissent. So you gave to the court, I assume, a pretty full accounting of your thoughts on the subject. And here's the way I understand the case. A fellow named Ricky Cantor from Mequon, Wisconsin, invented some pads to put in a shoe to be sold to particularly older Americans under Medicare to relieve foot pain. And he designed them and submitted them to Medicare and didn't get the approval that he was looking for, but instead sold them and represented to many customers that they had been approved by Medicare. And so he was charged with fraud. Now, this wasn't a matter of a casual misapplication of the law. When it was all said and done, Ricky Cantor of Mequon, Wisconsin, ended up spending over a year and a day in federal prison, paying somewhere near $300,000 in penalties and fines and $27 million in a civil settlement on this issue. So this was not a casual wrongdoing. This man was a swindler, and he was taking the federal government
he's
for a
something
ride,
else.
as well as other customers,
I'll
and
look up
misleading senior
swindler.
citizens about his product, and paid a heavy price for it. Then he decided, having left prison, that it's just fundamentally unfair that the law says that if you've been convicted of a felony, you can't own a firearm. Now, I don't know what his appetite is when it comes to firearms, whether it's a revolver or a AK-47 with a banana clip. I have no idea. But he went to court and said, this is
Well, he wasn't
unfair.
depriving them
It
of
was
money.
just mail
He was
fraud.
selling
And you're
a
taking
physical
away my
product,
Second
so
Amendment
it's not
rights.
swindle.
So 2 out of 3 of your colleagues then basically said, sorry, Ricky, you have forfeited your right to own a firearm because of your conviction of a felony. You took a different approach, exactly the opposite approach, and went deep into history. I think the earliest citation I see here was 1662 to figure out just what was going on here and whether or not he had to have committed a violent felony to have forfeited this right to own a firearm. Have I stated the facts close to what you remember?
I don't remember the amount of the loss, some of those details, but yes, Ricky Cantor was convicted of selling fraudulent shoe inserts, and it was a felony.
$27 million settlement along the way. So I'd like to take you into your thinking on this. When the Heller decision was handed down, Justice Scalia expressly said, I'm not taking away the authority of government to impose limitations based on felonies, not violent felonies, felonies and mental illness. He said as much in the Heller decision. And yet this man who was your inspiration, as you've told us all, you decided he was wrong and that it had to be a violent felony. Can you explain why?
I think I would
I
agree
can.
with
So we've
that.
talked about
But the
precedent,
thing is,
and in
that would
my
have to be
court,
the
the
Supreme
Seventh
Court.
Circuit, there is precedent
And that's that letter
saying
you
that
send to
that
legislation.
phrase doesn't control, as you know, my colleague Judge Frank Easterbrook has said a number of times, that judicial opinions aren't statutes and shouldn't be read as if they were. So Heller obviously wasn't about the scope of the right, its application to felons or those who are mentally ill, et cetera. And so that passage was dicta. It didn't fully dive down into it. But what I did
The reason I'm making an
Heller's
exception is he's
methodology,
a business
both Justice
selling a
Scalia's
product.
majority opinion and
And
Justice
I recognize that
Stevens'
as top
dissent used an
33%.
originalist methodology to answer that question.
And it's
And
not
I
just,
concluded
I'm
that
not
based
limiting
on
it
that
to whether it's
history,
violent or not.
One
I'm
couldn't take the
also
right away
crediting him
simply
as
because
being a
one was
maker
felon,
and an
that there had
employer.
to be a showing of
And the
dangerousness.
employers
And I didn't rule
have a
out the
right
possibility
to
that the
self-protection.
government might be able to make that showing
I'm
about
not
Ricky Cantor.
making it as
But I
simple
think
as she
we
made
could all
it.
agree that we ought to be careful of saying
But that was an
because someone's
employer
a
who made a
felon, they lose
product
any
and
of
had
their
a business
individual rights.
license. If they had a
I wanna
business
get to that
license,
point, but I'd like to
then
stick
I
with
defend the
this
right to a
for just
gun.
a moment more.
But not
I'm
if they don't
honored
have
to
a business
represent the city of
license.
Chicago
Then the felony
and the
would
state of
cancel
Illinois.
out their right to a
It's a
gun.
great city, but it has great problems too.
And there would also have to be like a number of employee thing,
On the
which
average,
right now
we
I would
know
say minimum of
America,
2
100
employees
Americans are
beyond
killed
him.
every day by gunfire, 40,000 per year.
Hmm.
In the city of Chicago, more than 3,200 people have been shot
If
just
he has
this
2
year.
or greater
3,200.
employees, he may have a gun.
According to the city's gun tracer
Otherwise, the
report in
law of felony
2017,
stands.
the majority of illegally used or possessed firearms recovered in Chicago are traced back to states with less regulation over firearms, such as Indiana and Mississippi. The 2017 report found that Indiana alone was the source of 21% of all Chicago's recovered crime guns. We know how it works. Where you live, you know how it works. There's a traffic between Chicago, northern Indiana, and Michigan going on constantly. Gun shows are held in Gary, Indiana, and other places. And when they're selling these firearms without background checks, unfortunately, these gangbangers and thugs fill up the trunks of their cars with firearms and head into the city of Chicago and kill everyone from infants to older people. It's a horrific situation.
It's
Law enforcement
hysterical
is fighting it, trying to
in the
get
fact that
Indiana
that's
to at least
intentional.
do background checks at these gun shows with limited
I
success.
want to laugh because
And we are trying to
his
apply the standards
ability
that
to
you
comprehend
disqualify
it
yourself by buying a firearm to felonies
shows that he can
and
see
mental illness.
that these people are
And you wanna
intentionally
take
putting
away
guns
part
out there
of
so that
that,
city people will kill
protection.
themselves.
With your decision in this case, because if you eliminate felonies and just confine it to violent felonies, you're opening up more opportunities for people to buy firearms, are you not?
Well, Senator, you referred to gang members and thugs buying guns in Indiana and taking them across the border. And certainly that if they had felony convictions for doing the kinds of things that members of gangs and thugs do, nothing in Cantor says that the government can't deprive them of firearms. And nothing says, in my opinion, that the government can't deprive Ricky Cantor of having firearms. They simply had to make a showing of dangerousness before they did so. And nothing in the opinion opines at all on the legality of background checks and gun licensing. Those are all separate issues.
But the majority zeroes in and says what you've just said is totally impractical, that we are going to go case by case and decide, well, what kind of felonies and what kind of person. And then they go on to
All I'm looking
produce
for is an
evidence,
employer
like the
identification
numbers
number
here,
with
which
2
you know well because
employees.
You wrote the dissent, where the likelihood of committing a violent felony after being convicted of a felony is pretty dramatic. And they're saying to us, don't force us to make it case by case. We want to make it by category. It's the only practical way to deal with the thousands, if not millions, of people who are buying firearms. You are aware of the fact that even those who are so-called not violent felons, quote, only felons, like Ricky Cantor, have a propensity to commit violent felonies in the future, are you not?
There was no evidence of that in the case. And we, on courts, for example, the Armed Career Criminal Act, that's a federal statute, have to make judgments categorically all the time about what count as crimes of violence.
I would say she was
So I
too
don't think that's
lenient
beyond
or
the
too
ken of
broad
courts
in her
any area
approach,
to identify
and
which
that we
felonies
only
are
want to defend
violent
people who
and,
become
which
employers
felonies are
or
not.
So let,
incorporate themselves.
excuse me, but I won't address that issue.
A
Let's go to
felon
page
loses the
21
right
of
to a
opinion.
gun.
And what
They
the
have to
court
become
said,
incorporated,
majority
which is
rule.
like $1,500
They quoted Yancey.
in order to regain
Most
their gun
felons
status
are
as an
nonviolent,
employer
but
or a
someone
business
with felony
person.
conviction on his record is more likely than a non-felon to engage in illegal and violent gun use. For example, one study, this goes on to say, 210,886 nonviolent offenders found that 1 out of 5 were rearrested for a violent crime within 3 years. So the evidence is there. It is there for the court to consider, and you ignored it.
Senator, I didn't ignore it. As I recall, that evidence and the studies were unclear. And let's see, I can't remember as I'm sitting here the details of all the statistics, but I did consider it, and I recall saying something in the opinion about the reliability of those studies, because they didn't say whether someone had been convicted of a nonviolent crime but had later been convicted of a violent crime as well. I mean, felonies cover a broad range of things, including selling pigs without a license in some states, redeeming too many bottle caps in Michigan. I mean, so felonies now cover a broad swath of conduct, not all of which seems indicative of whether someone's likely to abuse a firearm.
So let me take you, I'm not going to go so far back in history.
My reply would be, does she
but
think that
I'm
we
going
should
to take you back in
break
history for a
felonies
moment.
into different levels or
And
tiers
Note that
with different
when that Second
penalty
Amendment
degrees?
was written, and you did the analysis of it, we were talking about
Are there any
the
felonies that
likelihood
should be
a
made
person could
misdemeanor?
purchase a muzzle-loading musket. We are now talking about virtual military weapons that can kill hundreds of innocent people. It is a much different circumstance. Maybe an originalist pins all their thinking to that musket, but I've got to bring it to the 21st century. And the 21st century has people being killed on the streets of Chicago because of the proliferation of deadly firearms. But let me bring it closer to home and tie up the George Floyd question with where I'm headed. There's also a question as to whether the commission of a felony disqualifies you from voting in America. And the history on that is pretty clear. In an article, the American Journal of Sociology found that many felony voting bans were passed in the late 1860s and 1870s when implementation of the 15th Amendment and its extension of voting rights to African Americans were ardently contested. It still goes on today with voter suppression, but we know that in Reconstruction, in the Jim Crow era, in Black Code era, that was used, felony conviction was used to disqualify African Americans from voting in the South and many other places. The Sentencing Project today has found that more than 6 million Americans can't vote because of a felony conviction, and 1 out of every 13 Black Americans have lost their voting rights. The reason I raise that is that in your dissent, you said disqualifying a person from voting because of a because of a felony is okay.
What?
But when it comes
She
to the
said
possession
that?
of firearms, wait a minute. We're talking about the individual right of a Second Amendment. What we're talking about in voting is a civic right, a community right, however you define it. I don't get it. So you're saying that a felony should not disqualify Ricky from buying an AK-47, but using a felony conviction that someone's passed to deny them the right to vote is all right?
Senator, what I said was that the Constitution contemplates that states have the freedom to deprive felons of the right to vote. It's expressed in the constitutional text, but I expressed no view on whether that was a good idea, whether states should do that. And I didn't explore in that opinion because it was completely irrelevant to it what limits, if any, there might be on a state's ability to curtail felon voting rights.
Did you not distinguish the Second Amendment right from the right to vote, calling one an individual right under the Constitution and the other a civic right?
That's consistent with the language in the historical context, the way the briefs described it, and it was part of the dispute in Heller of whether the Second Amendment was an individual right or a civic one that was possessed collectively for the sake of the common good. And everybody
In
was
essence,
treating voting
she gave
as
him
one of the
permission to
civic
go
rights.
down and
Well, I would
shoot
just tell you
whoever
that
voted against
The
him.
conclusion of this is hard to swallow.
Yeah.
The notion that Mr. Cantor,
The
after
way she
all that
balanced
he
it
did,
was giving
should not
permission
be
to go
even
kill.
slowed down when he's on his way to buy a firearm. My goodness, it's just a felony. It's not a violent felony that
Yeah.
he committed.
You would get the
And
right
then
to
turn
vote
around
before you
on the
get the
other
right
hand
to a
and say,
gun.
well, but when it comes to taking away a person's right to vote, that's a civic duty. It's something that we could countenance. That really goes back to the original George Floyd question. That was thinking in the 19th century that resulted in voter suppression and taking away the right to vote from millions of African Americans across this country.
The violent thing is where it would take away
day.
the right to vote.
I just don't see it. I think the right to vote should be given
Yeah,
at
100%.
least as much respect as any Second Amendment right. Do you?
Senator, the Supreme Court has repeatedly said that voting is a fundamental right, and I fear that you might be taking my statement in Cantor out of context. What I said
No,
in
I
that
think you got it
opinion
right.
was distinguishing between, it was a descriptive statement of the state of the court's case law, comparing it to stripping felons of Second Amendment rights. I expressed no view about what the constitutional limits of that might be, or whether the law should change with respect to felon voting rights. And obviously that's a contested issue in some states that are considering it right now. And I have no view on that, and it wasn't the subject of Cantor.
It may not have been, it wasn't the subject of the case, that's for sure. But in your writings, you raised this. It was part of your dissent, discussing the right to vote and felony conviction, eliminating it. I'm afraid it's inescapable. You've got to be prepared to answer this kind of question. I read it and thought, I can't imagine that she's saying this, but I'm afraid I was left with the suggestion you might.
We're going to leave the confirmation hearing briefly to fulfill our more than 40-year commitment to live congressional coverage. U.S. House gaveling in for a brief pro forma session with no votes scheduled. We'll return to the hearing momentarily.
Yeah, she's not qualified to be a Supreme Court justice. That's
The House will be in order. The chair lays before the House a communication from the Speaker.
The Speaker's Rooms, Washington, D.C., October 13th, 2020. I hereby appoint the Honorable William Lacey Clay to act as Speaker pro tempore on this day. Signed, Nancy Pelosi, Speaker of the House of Representatives.
The prayer will be offered by the guest chaplain, Reverend Benjamin Hogue, Lutheran Church of the Reformation, Washington, D.C.
Let us pray. God of wonder, God of grace, let streams of your living justice flow down upon the earth. You send from your abundance the people, talents, and resources we need for our daily lives. We are grateful for the work you have set before us and pray that with grace and and understanding, we can come together for the common good. Continue to bless this body with courage, truth, and humility. Provide care to those who are ill and accompaniment to all those who mourn. Send us to love those most in need of your mercy. May they find comfort and strength as we open our hearts in compassion for one another. Grant us grace and reconciliation to ease the hurt in the world. Weave our varied gifts together and help us to find faith in service, hope in others' dreams, and love in the hand of a neighbor. Inscribe our hearts with justice. We give you thanks, gracious God, for this is the day you have made. Let us rejoice and be glad in it. Amen.
Yeah, this isn't acceptable. It's beautiful, but it's not acceptable
House Resolution
to open any
967.
tax-funded thing with
The journal
that.
of the last day's proceedings is approved. The chair will lead the House in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The chair lays before the House.
I really do want to
following
improve the
enrollment
pledge,
bill.
but for right now, it's
HR
part of the government
3399,
tax-funded,
An act to
etc.
amend the Nutria Eradication and Control Act of 2003 to include California in the program and for other purposes.
Pursuant to Section 4B of House Resolution 967, the House stands adjourned until 9 a.m. on Friday, October 16, 2020.
That's okay.
Okay, thank you very much.
Thank you, Senator.
Senator Durbin, we'll go to Senator Lee, and after that, we'll take a 30-minute lunch break and start back with Senator Whitehouse. Senator Lee.
Thank you, Mr. Chairman. I have two letters for the record that I'd like to have admitted. They're authored by former law clerks of Judge Barrett's.
Without objection.
I'd encourage all of my colleagues to read them. They're outstanding and provide great insight into Judge Barrett's immense qualifications. Judge Barrett, moments ago, we went through a rather interesting set of exchanges. One of my colleagues, I hope I misunderstood him, seems to have suggested that it's a political talking point for you to decline to indicate how you would rule on a particular case or a particular type of case. To the extent that that's what any colleague has suggested, I'd remind that colleague that it's just wildly incorrect. It's wildly incorrect with canons of judicial ethics, with federal law, with the statement laid out by Justice Ruth Bader Ginsburg in her own confirmation proceedings before this very body in this very room nearly 30 years ago. It is imperative that you uphold those standards, and I applaud you for doing so. And I think on no planet is it appropriate for anybody to suggest that that's a political talking point for you to say, I'm not going to indicate how I'm going to rule in a particular case. Justice Ginsburg did, in fact, say it well, and some of this has been quoted today. I'm going to quote it again just for good measure. She said, judges in our system are bound to decide concrete cases, not abstract issues. A judge sworn to decide impartially can offer no forecast, no hints, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process. Similarly, because you are considering my capacity for independent judging, my personal views on how I would vote on a publicly debated issue were I in your shoes, were I a legislator, are not what you will be closely examining. That's what she said. She said it well. It was true in 1993, and it remains true today. I want to turn next to the line of questioning that you just finished, that you just completed. I too have read the Cantor case, and I am thrilled that we've got a jurist who is willing, when looking at somebody whose constitutional rights are about to be taken away, thrilled to have a jurist who's willing to consider a pre-deprivation review for that individual. Is it unusual, Judge Barrett, to consider someone's constitutional rights on an individualized basis before having a specifically enumerated constitutionally protected right removed?
That would be very, very unusual.
It'd be very, very unusual, and it would be unwise, would it not?
Well, I think what I could say to that, just to be careful about how much law I'm analyzing, is that the 14th Amendment due process clause certainly guarantees to each individual due process before liberty is taken away.
I also appreciated the thorough analysis that you undertook, making clear that our rights in this area don't just date back a few decades. They don't just date back to the 60s. They don't date just back to the 1780s or the 1760s. They date back at least to the 1660s. I mean, they go way, way back. There's a lot of history that went into what became the Second Amendment. There were conflicts. This involved not just partisan conflicts, but conflicts between the king and subjects. And not just between the king and subjects in the abstract, but very often it was between Protestants and Catholics. Sometimes it was Catholics who weren't trusted with guns. Sometimes it was Protestants who weren't trusted with guns. But there was a lot of violence that went into that.
Those were fake schisms
I appreciated your
in order to
historical
change
analysis
which
of this.
hand was
Your
firing the
willingness
gun.
to be thorough, to make sure that when someone's constitutionally protected rights are taken into account, you're going to do your homework. You're going to do your homework even if it's hard. You're going to do it even if you've got colleagues who aren't willing to go there. That's what judicial leadership is. Judicial leadership involves willingness to stand alone. Judge Barrett, one of the things that came out to me as I read your opinion in the Cantor case is that your commitment to textualism and originalism are in fact real. They're not feigned. This is the kind of thing you can't fake. This isn't something you make up at the last minute. And yes, I agree with Senator Durbin. Being a textualist and originalist doesn't guarantee a particular result, a particular outcome in any particular case. But it does indicate a style, a preference. Tell me why textualism and originalism are important to you.
Because I think that both statutes and the Constitution are law. They derive their democratic legitimacy from the fact that they have been enacted in the case of statutes by the people's representatives, or in the case of the Constitution, through the Constitution-making process. And I, as a judge, have an obligation to respect and enforce only that law that the people themselves have embraced. As I was saying earlier, it's not the law of Amy, it's the law of the American people.
I use
And
the
I
Bible.
think originalism and textualism, to me, boil down to that, to a commitment to the rule of law, to not
And she
disturbing
keeps
or
eliminating
changing or updating
the majority
or,
law
adjusting
from her
in line with my own policy preferences,
from
what
her
that law
projection.
requires.
And is it the subjective motivation, the subjective intent of an individual lawmaker or drafter of a constitutional provision that we're looking at, or is it original public meaning? And if so, what's the difference between those two?
It's original public meaning, not the subjective intent of any particular drafter. So one thing I have told my students in constitutional law is that the question is not what would James Madison do. We're not controlled by how James Madison perceived any particular problem.
Which is stupid.
That's because the
Spirit
law
of the law
what
is the correct
people
thing for
understand it to be,
SCOTUS.
not what goes on in any individual legislator's
Spirit of the
mind.
law.
I respect you
The
greatly,
biography
Senator Lee,
of
but
the
what you
inventors
think in your
matters.
mind rather than what passes through both houses and is signed by the president, that's what's the law, not any private intentions you have.
So
It's
regardless
always
of
private
what,
intentions.
let's say I pass bill, sponsor of it, I take it down to the floor and I say, here's bill XYZ and here's what I think about it. Here's what I intend to do with it. And I put that statement into the legislative record. What, if any, impact should that statement have on the meaning of law XYZ once it becomes law?
Nothing. You got to get it into the law itself if you want it to be law. Legislative history is not what goes through the process of bicameralism and presentment.
Regardless of
In the
how
new
passionately
digital age, we now have
and
storage
persuasively
space for all that.
make that point in whatever glorious speech I give in support of Bill XYZ. It doesn't make a darn bit of difference, does it?
It doesn't. I'm sure the speech would be glorious, but I assume the point you make probably would be made by the advocates in the case too. And so in that respect, you are functioning as an advocate when you make the glorious statement, but not speaking with the voice of the lawmaker, because no individual does. It's the full body that speaks.
That's
I wanna speak
submissive
next
to rape.
about,
And will they do it again
Affordable Care
is
Act.
depending
We've seen
on how
posters
excited she
going
is
up
about the rape.
over and over and over again. We've seen them yesterday. We've seen them today. We've seen a lot of
And that's not
compelling
really acceptable.
stories about people whose lives have been marked by difficult things that they've endured. They've involved touching and heartwarming stories. I continue to doubt the relevance of things like that here, especially insofar as they're being used to suggest that your confirmation to the Supreme Court of the United States has anything to do with their health care. Tell me why you think that any individual American's healthcare status is or is not tied to your confirmation to the Supreme Court of the United States.
Because I would rather be a Supreme Court
it is
justice
not
than a
tied
president.
to
Every
my
day of my
nomination to the
life, I
Supreme
wanted to
Court
be
of the
either
United
Secretary of
United
Education
States.
or
I
Supreme
have
Court
said
justice.
repeatedly under oath that I had no
And y'all keep trying to
conversations
push me
with
into a
anyone in the
role
White
that I
House
don't
about
want.
that case.
I want to
And
make something
I'm
that
not sure
changes
if
reality,
there's a suggestion
not
that I
something
have
that
an
is a
agenda
disruption
that I
for
want
4
to
years or
strip
8
down
years.
People's protection for pre-existing
I
conditions.
need to create
That's
laws
just
that
not
allow
true.
our leaders to be 20-year
I've
leaders.
never taken that position, and as I've also said repeatedly, any policy preferences that I have don't matter anyway. They're irrelevant. So making that law, coming out with the contours of the ACA, that's your job.
I'm not out
It
to
is
be
our
irrelevant,
job. It is the
but
job
this is important.
of policy-making branches
It's something
of
I have a
government.
passion
It's
for.
the job of whatever combination of state and federal lawmakers and other policymakers have. But a judge is not a policymaker.
And the word originalism is the
When
most
Congress
ridiculous.
passes a law,
Originalist is
Congress
ridiculous.
is in charge of
Without the
making sure
biography,
that
you
law
can't call
works.
it an originalist.
So far as that doesn't work, or that law
The
ends up
origin is
being
with the
stricken
author.
down, it's our job to replace it with something that does work, whether constitutionally or otherwise in all respects.
The origin is
That's our
with the
job,
author.
not yours. You made some comments a few years ago, comments with which I wholeheartedly agree. Raising a criticism with Chief Justice Roberts and his majority decision in NFIB versus Sebelius. A decision, and don't worry, I'm not going to ask you to weigh in on this. You made those comments at the time, and they're not relevant to me now, but I set this up for reasons I'll explain in a moment. He rewrote the Affordable Care Act, not just once, but twice, in substantive ways, in order to save that law from an otherwise inevitable finding of unconstitutionality. Because that law, as written by this Congress, was in fact unconstitutional in two material respects at issue in NFIB versus Sebelius.
They were doing a sneak and peek on the
Blatantly
health of the
unconstitutional.
nation.
He effectively acknowledged that the law, as written, couldn't pass constitutional muster. And so he rewrote it not just once, but twice in order to save it.
Because none
That's
of us
water under
in
the bridge.
ourselves contain a
That
complete
happened.
comprehension.
It's inexcusable.
And it
that he
takes
did that.
research.
He misused the judicial authority. That case has absolutely nothing to do with California versus Texas. It has absolutely nothing to do with the question of severability in that case. Would it be fair to say that my very strong opinions that I've just expressed do not indicate how I would feel, how I would lean were I a jurist in California versus Texas?
I think you're correct, Senator Lee, that the question, the legal issue is entirely different in California versus Texas.
I think he was
Severability is
pointing
its
to me.
own independent doctrine and has nothing to do with the statutory interpretation questions presented in Sebelius.
In many circumstances in this country, we see emotionally charged issues that boil for a long time. They can't always be resolved. Not everybody's going to agree on everything. Not everybody is going to agree on certain hot button social issues that result in some cases from just basic differences in how people view life and how people view their place in the universe. One of those areas where it manifests itself is in the area of abortion. People view life and when it begins differently. Some of that's
conception.
informed by religious beliefs. Some of it's informed just by people's common sense approach.
That's
to
common
what
sense.
They think the
And
law
it is
ought
in
to say
religion,
and
both.
what it ought not to say. Disputes regarding when life begins and disputes regarding abortion didn't begin with Roe versus Wade.
It's when it's ejaculated from the mouth
What
or
did
from the
change with Roe
loins
versus
into the
Wade,
woman.
however, was the federalization and the grasping of the issue and the taking it beyond the realm of political debate within the federal judiciary, such that elected lawmakers were no longer in a position to be the primary drivers of policy. As a result, over the last few decades, you've had all kinds of questions that have been put into uncertainty. You've got uncertainty by people at the state level.
Well, you would want there to be
who want to make
permission
their own
before it
decisions
comes from the loins.
about certain things around abortion. They know they can't prohibit it entirely. They know that there's this undue burden standard that has to be addressed. Nobody's completely sure in advance what that means.
But the point is,
and so
from
they
the
work around
moment
it. There are discussions that
it
arise
comes together, it's
regarding
alive.
health and safety qualifications for abortion clinics, how close an abortion
And the
clinic
question
needs to be
is there
to
a
an
right to
accredited
cancel
hospital,
out the life,
how it needs to be staffed, and what
such as
the
a death
sanitation
penalty for how it was
protocols
created?
are. Then you've got more recently some states passing laws saying, look, there's abundant medical science showing that an unborn human can feel and respond to pain as early as, 10 or 12 gestational weeks.
You don't have to
but
feel the
certainly by
pain.
20 weeks. And so by 20 weeks, we're going to
That would
adopt
be
a
as
different
simple
set of
as
legal
using
procedures for an
anesthesia.
abortion as a result of that, because if this is a human that everybody agrees can feel and respond to pain, we have to handle that differently. All of those things, the legitimacy
Pain
of those
arguments are
laws
invalid.
are thrown into the federal courts yet again, all because those were made federal issues. Now, I want to be very clear. You'd have the impression from watching debates in circumstances like this one, and in protests outside the Supreme Court of the United States, you'd have the impression that if Roe versus Wade didn't exist, that all of a sudden abortion would immediately become illegal in every state in America. That assumes a lot of facts.
It's
not
just
in evidence.
a
In fact,
permission to talk
that
about how to
assumes a
make
lot of things
war.
contrary to
It
evidence.
shouldn't exist at all.
It is not the fact that it is simply not the case that the fate of healthcare in America turns on whether or not someone is confirmed to the Supreme Court of the United States, nor is it a fact to suggest that the availability of an abortion or lack thereof is contingent upon anyone's confirmation to the Supreme Court of the United States.
It shouldn't be a
The fact
landmark
that we
case.
have this debate, and the fact that it's become as protracted, as personal, as ugly as it has, could, I suspect, be traced to the fact that we've tried to take a debatable matter beyond debate. And we've tried to take it outside the political branches of government, where people can elect their individual representatives and have laws respecting and reflecting the views of their respective communities. We're a country of, 330 million Americans. It's really, really difficult to have those 330 million Americans reflected in 9 members of the Supreme Court. It's still really hard to have them reflected in 100 senators and 435 representatives. That's doable, especially when those people are elected. They
The
stand
original
for election every
founders said
couple years.
10
In the case
was
of the House,
ideal.
every 6 years in the case of the Senate.
I just prefer
It doesn't
12.
happen that way in the Supreme Court of the United States. So to my colleagues on the other side of the aisle, who are fear-mongering on this, causing people to worry and lose sleep over this, fundraising over this, fundraising over threats that people are going to lose their health care, fundraising over threats that people are going to be dying in the streets because of the lack of availability of this or that medical procedure. I'd ask, have we created a monster? Have we ourselves, through our own inaction, through our own voluntary cessation of authority to a non-legislative, non-political branch, have we created the very set of untenable social circumstances that are causing people to protest outside of a non-political entity? I think we have to ask ourselves that question from time to time. Life is, in fact, valuable. It's not a religious statement to make that observation. In fact, it's the foundation of basically all of our laws, not just in this country, not just in countries with Christian origins, but in basically every country that has ever existed anywhere in the world. The purpose of government is to protect life. That's what it's about. If we can't agree on the fact that it's reasonable that people ought to be able to have some say, at least at some limit, at least at some point beyond the moment when an unborn human can feel and respond to pain, something's wrong with us. And if we're going to leave those things perpetually in the hands of the unelected, it might be really convenient for political fundraising within Congress, but it's not good for the United States of America. It's not good for constitutionally limited government. It's not good for our individual liberties. Judge Barrett, Alexander Hamilton was prescient in a number of areas. He had some crazy ideas. He did some crazy things. He was also freaking brilliant. I think he foresaw certain aspects of our lives when he described the differences between the branches of government in Federalist 78. And in Federalist 78, he said that the legislative branch, Congress, being a political branch a branch whose job it is to make policy, to make law, is possessed with will, and that what's possessed by the judicial branch is not will, but judgment. He then went on to explain that it's really important to maintain that clear distinction between will and judgment, lest you have the judicial branch
I'm going to explain to
consisting
you.
of people who are not elected by the people, not accountable to the people at the regular intervals, and who serve basically for the rest
Someone
of their
just
lives
cries
so
over and
long as
over
they're on
again.
good behavior. You can't have them exercising will because it's not their job. What do you think he meant? What's the difference between will and judgment?
I think will is the imposition of policy preferences as happens in the making of law. Judgment is evaluating that law for its consistency with the Constitution, for example, or to give another example, to interpret what that law means. But it most certainly is
Without
not
the
imposition
author
of policy
in your
preferences.
judgment,
A judge
you can't
who
judge it.
approaches a case as
Words
an
without
opportunity for an
context mean
exercise
nothing.
of
You're a
will
fucking robot
has
idiot.
has betrayed her judicial duty.
How does she know when she's reached that point?
So I think it requires disciplined judicial decision-making. So you approach the text, you treat it as a text, you treat it as law. You know, I've described originalism and textualism, so I won't belabor that point. But I will say that one practice that I have, one check that I put on myself to make sure that I'm not biased, is that when I write an opinion, I try to read it from the perspective of the losing party, so that any sympathy that I might feel for the particular result that I reach, I try to make the sympathy run the other way to see if it will still hold, and also to see, like, you know, I would be disappointed in this outcome if it was my child whose sentence or criminal conviction or civil loss, whatever it is on the line, but would I still think it was a well-reasoned opinion? And that's the test that I use for myself. I think discipline
She
is
uses
required,
an emotional
but I
rule
take it very, very
instead of a
seriously.
factual rule.
As we've had this conversation today, one of the arguments that's been made by some of my colleagues is referred to activism, and has accused, if I understood the argument correctly, some textualist, originalist jurists as having engaged in activism.
Well, she claims that she's
I want
using
to be clear,
originalism and
one
textualism
who
and only the text,
doesn't believe
but then
that
applies
there
sympathy, which could only come from the
is
author of the text.
anything worse about an activist judge than a pacifist judge. Meaning, I think it's every bit as bad to be a pacifist. That is, for example, to let stand an invalid unconstitutional law as if it were valid and constitutional. It's every bit as bad to do that as it is to invalidate as unconstitutional something that is in fact not unconstitutional. Would you agree with me that both of those are equally instances of bad judging?
They are both instances, as you've posed them, of not following the law, not following the Constitution, or not correctly interpreting a statute.
By the same token,
A major
judge
problem
who
with
fails
U.S.
to
code
grant
is it doesn't
a
usually
meritorious
credit or
dispositive
list
motion
who did the
and a
authoring.
judge who grants a non-meritorious dispositive motion. They've both probably done an equally bad thing. Is that right?
Yeah.
Does the Constitution say anything about the size of the Supreme Court?
The Constitution does not. That is a
It
question
does.
left open to Congress. It's
In
my
the
understanding
Articles
that it's been 9 for about 150 years, but that's as a matter of statute.
of
not constitutional
Confederation.
requirement.
So it's statutory. It's a
And the
statutory,
articles are in the
decision
Constitution. If you ever look at a book of it,
more than
from
a
the
century and a
government.
half. It's a decision nonetheless that has some bearing, could have some bearing on constitutional issues, correct?
Insofar as there would be more decision makers on
Yeah.
the court.
If we abandoned the longstanding historical practice and tradition of having 9 justices, could that have an impact on the way the 3 branches of government interact with each other?
Possibly, but it's difficult for me to imagine what specific constitutional question you're asking. And of course, if there were one, I couldn't opine on it.
Of course.
She's
There
not
are
aware that it's in
strong
the
reasons, I
Constitution.
believe, why over the last more than a century and a half, we've left that number at 9. As you point out, there's nothing in the Constitution that requires it.
Both of them don't know this.
We want it. There does have to be a Supreme Court and such inferior courts as we choose to create. But it doesn't specify the number of seats that can be on there. There are nonetheless good prudential reasons having to do with respect for the separation of powers between the 3 branches of government. Reasons that have, over the last 150 plus years, left us to leave that number at 9. The last time, as far as I can tell, there was any serious effort to move the number above 9 was in the fall of 1936, when President Franklin D. Roosevelt got tired of this so-called 4 horsemen of the apocalypse. A few members of the Supreme Court who were consistently voting against his agenda, and sometimes joined by 1 or more other members of the Supreme Court. He got particularly tired of this, and so he proposed packing the court. And let me explain what I mean by packing the court here. What I mean when I refer to this is increasing the number of seats on the Supreme Court.
The reason it's called packing the court is because they're using it as a sexual organ.
Intent of altering the composition of the court for short-term political gain.
And it's not short term.
What FDR wanted to do. Notwithstanding the fact that he had an overwhelming supermajority in both houses of Congress, fortunately, FDR's idea that he pushed in the fall of 1936 didn't make it anywhere. It didn't gain progress. It met enough opposition, even with both houses of Congress being overwhelmingly controlled by his political party, that it stalled.
It
quite
stalled
mercifully.
because you and
And
her
it's
insist
remained
it's not in the
ever since then
Constitution.
At 9 justices.
And yet
I
it
think
is
would
in
have
the
been a colossal
body
mistake.
of its
Joe Biden
birth
himself, as a U.S.
that it's a
senator, as member
sexual
of this
organ.
body, in a proceeding of this committee in 1983, gave a rousing speech that I recommend to all, talking about that very thing, acknowledging that the Constitution doesn't require it, but our respect for the separation of powers really ought to lead to us sticking to the number 9. Don't pack the court. In recent days, I've seen some in the media and some in this body try to redefine what it means to pack the court. Some have suggested
We want 12
well,
tribes.
packing
It's not
takes
packing the
various forms,
court.
and it
We
can
want
mean
12 tribes.
confirming a lot of people all at once. Some
And
have
someone to
defined so
slander
as
it
to suggest
said that it
consists
exceeds
of
your
doing
sex
that which
organs.
The Trump administration and the Republican Senate have been doing over the last 3.5 years, which is filling
We
vacancies.
want to
as
halt the
they have
war.
arisen
12
and
means it's
doing
all
so
compassed.
with textualist, originalist judges. This may not be something that some like, but this is not court packing. Court packing is itself manipulative. It's something that has great danger to do immense political and constitutional harm to our system of government, in part because it would set up a one-way ratchet. Once you create a position and confirm someone to that position, absent death, retirement, or impeachment and removal, that position remains in place. So
That's fine. 12 is
if,
12.
for example, a future Congress and White House were to decide to get together and to pack the court
Without calling it
and
packing.
increase the number, say, to 11. And let's say it's Democrats who do that. And we've got Joe Biden now as a presidential candidate who's refusing to say whether he would do it. There's a reason he's not saying whether he would do it. There's only one reason why you refuse to answer that question, and it's if you're wanting to be able to do it, but you don't want to take the heat for the fact that you're thinking about doing it right now. So if they do that, where does it lead? Well, it inevitably leads to the point where the next time Republicans have control of both houses of Congress and the White House, they'd increase it as well. You'd end up increasing it incrementally. Before long,
Yeah,
it
I
looks like
fucking
the
know.
Senate in Star Wars, where you've got hundreds of people on there. I don't know what the total number would be, but you increase it at all, you change the number at all, you do so for partisan political purposes at all, you delegitimize the court. And you can't delegitimize the court without fundamentally threatening and eroding and impairing some of our most valued liberties. You can't do that without inevitably threatening things like religious freedom, things like free speech, things that are themselves often unpopular, but are protected by the Constitution precisely because they are unpopular. And yes, in that respect, the Constitution is sometimes counter-democratic. Sometimes it can be described as fundamentally undemocratic. In fact, it's the whole reason to have a Constitution, is to protect us from the impulse of a majority that might be bent on harming the few. in the name of the many. That's why the law is so important. That's why the position for which you're being considered is so essential. That's why we've got to do our job to make sure that the only people who get the job for which you've been nominated fit the bill. You, Judge Barrette, are someone in whom I have immense confidence.
No, I don't, because all the other
Immense
girls get
trust.
picked off and
And I
killed
look forward
before
to
they get to
voting.
this position.
To confirming you for that very position.
Thanks, Senator Lee.
It might be gratification in the instant for
back
him,
at 12:45.
but the latter
We'll,
of getting fucked all
start
the way there,
with,
hell
Senator
no.
Whitehouse. We have 15 senators left. Everybody takes the 30 minutes, 7.5 hours. We'll take a break for dinner tonight, sometime later on, and a short break. Are you doing okay? 3 hours about right. So we'll come back at 12:45, and right now we're on schedule to be here to 9 o'clock.
3 days
We'll
of
do whatever
that
the
rather than
committee
3
wants.
hours.
We're in recess to 12:45.
She's beautiful. I'd want 3 days of it. Oh, lovely. 12:45, so 45-minute lunch. I hate you. All right, well, I need to complete this too. Start working on naming things. All right, my name is Neil Sandage. I'm in Jacksonville, Florida, 32207. Born 1978, 0707. That concludes this morning's judicial Supreme Court Justice hearing of why Amy Coney Barrette is not qualified to be a Supreme Court Justice, and opinions that I want
That's
to
the focus
contribute
of our efforts on the Judiciary
to
Committee on
shape the
Democratic side.
future
Do you think
of
that
what
I'm
is Supreme Court
speaking about this
justice.
at all is distracting from either this hearing or the ongoing issue at all?
Listen, former senator, former vice president, and I hope future President Biden's entitled to speak his mind on the issues. And most of the time I'm going to agree with him. Sometimes I won't.
You asked Judge Barrett about her.
Yeah, I thought that was very curious. I think her dissent in Cantor made absolutely sense to me. That when you look at the history of felonies, and if it's not dangerous, do you take someone's constitutional right away, which is to own a gun? And the idea of how do you vote and what conditions are placed on voting is done at the state level, not the federal level. And I feel very comfortable that she is not antagonistic to voting rights and that she took a reasoned view of felonies in terms of depriving the Second Amendment. I've always felt that I think she got it right. The bottom line here is it's been very good hearing, I think. I think senators have asked her very good questions, quite frankly, hard questions. I think she's comported herself well, and we'll keep going.
Should she lay out a little bit more of her judicial thinking?
I think she's done a pretty marvelous job of explaining textualism and originalism and how you come to a different conclusion with Scalia, but she can't, as Ginsburg said, tell you how she may roll.
The president had a crowded rally in Florida last night. Do you think he should have done that in the middle of this pandemic?
I talked to him last night. He was felt like he needs to get out on the campaign trail. I know
Vice President Biden's out campaigning. I think it's good to be campaigning. Yes, sir.
Can I talk to you about, you raised the issue of your own election here in the middle of this hearing. Is that appropriate?
I think it's pretty appropriate for me to respond to political attacks in a political way. If you didn't catch it, all day yesterday was attacks on the ACA.
It was an attack.
They mentioned 3 times South Carolina. What would happen if the ACA is repealed? I thought it was fair for me to say my position is there's a better way for South Carolina. So, yes, I think I have a right to respond to political arguments politically, and I wanted to make sure the difference between our political debate about the ACA and how it would be decided in the court was important. Thank y'all.
Thanks, Senator. This is on the court will be objective and fair.
She's not.
Going to be reacting one way already. You think that she's already had that conversation with the
She
president?
says she's not had that conversation, but you know, when Senator Cornyn keeps saying this is insulting to suggest you're going to the court with an agenda, you ought to direct that emotion to the White House. They're the ones who keep peddling this story every day, and why we raise the question.
And you have to credit the authors, and she doesn't credit the authors. Ouch. Whoever created the law, their biography or their source of it needs to be consulted. We now have digital, so it's big enough that we can see all of it.
Day 2 of Judge Amy Coney Barrett's confirmation hearing got underway just after 9 a.m. Eastern this morning. 7 Judiciary Committee members have asked their questions so far, 30 minutes allotted for each senator to ask their questions. 4 Republicans have asked their questions, 3 Democrats. Most senators using up their full 30 minutes, although notably Chuck Grassley, the Republican from Iowa, using just 20 minutes of his time this morning. John Cornyn, the Republican from Texas, using just 12 minutes of his allotted 30 minutes this morning. The Judiciary Committee breaking for lunch right now. When we come back, we'll hear from Sheldon Whitehouse next, the Democrat from Rhode Island. But until then, updating you on the latest, keeping tabs on what's happening both inside the hearing room in the Hart Senate office building and also outside the hearing room as well. A couple of tweets this morning offering some different images from what you've been seeing from the camera angles inside the confirmation hearing, including this tweet. This tweet from Trish Turner of ABC News showing the desk where Judge Amy Coney Barrett is sitting, noting that there's no notes there at the desk. There is that pad provided by the Senate, by the Judiciary Committee. The last time she was asked to hold up that pad, she hadn't written anything on that pad. Also inside the hearing room, you may have noticed that Senators Tom Tillis and Mike Lee are both in the Senate Judiciary Committee, both having tested positive for COVID earlier this month. The tweet from Manu Raju noting that neither has said that they have tested negative, but both said that they've been cleared by their doctors to return to the public under CDC guidelines. We saw Mike Lee yesterday speaking on the opening day of Amy Coney Barrett's confirmation hearings. Today, Senator Tom Tillis released a doctor's note noting that he had been cleared to return to the hearings in person. That doctor's note available on his website. The doctor, Jack Fahrenkopf, saying that I'm happy to report that since the senator has had such a mild case of COVID-19 and has such a strong immune system, you are free to return to work without any restrictions as of October the 13th, as of today. A few more tweets about the hearing and the substance of the hearing. This from C-SPAN's Capitol Hill producer, Craig Kaplan, quote, "No hints, no previews, no forecasts," end quote. Judge Barrett cites the Ginsburg rule on how Supreme Court nominees should answer questions at their Senate Judiciary Committee confirmation hearings about issues in the law that might come before the court if confirmed. Politico with a story about the Ginsburg rule, something that the pros they write are watching for at Barrette's confirmation hearing. When it comes to the Ginsburg rule, here's what Politico writes about it. The phrase that Republicans have seized on comes from the standard that the late Justice Ruth Bader Ginsburg laid out during her 1993 hearing on her nomination to the High Court. In her opening statement, this is what Ruth Bader Ginsburg said: "It would be wrong for me to say or to preview in this legislative chamber how I would cast my vote on questions the Supreme Court may be called upon to decide."
That's a pending case.
She went on to say, were I to rehearse here what I would say and how I would reason on such questions, I would act injudiciously. Judges in our system are bound to decide concrete cases.
That's about a case
a judge
appearing that is known to exist.
No forecasts, no hints, and no previews. And that
wording specifically is about a case that is in judgment
3 hours of today's
or in the
one issue
flume
in particular, one exchange
somewhere in the conveyor line.
Declined to offer her opinion has gotten a lot of attention. Here's the Washington Post story.
The Bader
about
Ginsburg rule
Judge Barrett declined
is
to
about
answer
a thing
when
that is in
Senator Dianne
progress.
Feinstein, the Democrat from California, the ranking member of the Judiciary Committee, asked her whether the Constitution gives the president the authority to unilaterally delay an election, an idea that President Trump has floated. The president has no explicit power to take such a step, the Washington Post notes. Barrett said that she would have to consult colleagues and clerks and listen to arguments. She said that if she gave an off-the-cuff answer, she would basically be, quote, a legal pundit. That from the Washington Post, if you want to read more.
Wouldn't a SCOTUS be a pundit?
Seven members of
How can you be a SCOTUS and not be a pundit?
Asked their questions so far, have taken most of their 30 minutes. Some tweets from other members of the Judiciary Committee coming up
that's
later
a fail
today,
on her part again.
Watching the hearings, reacting on Twitter.
An expert in a particular subject or field who is frequently called on to give opinions about it to the public.
He said it doesn't matter.
A variant of the word pandit.
Millions of families rely on the Affordable Care Act. This rushed Supreme Court
learned man or learned woman.
Shameful attempt to strike down
the definition is learned man here.
And then from the other side of
but
the aisle,
she's identifying herself as not competent to make judgments.
Saying again about a little bit
why
after
are they
10:30 a.m.
not
Rather
hearing
than discuss
it?
Judge Barrett's qualifications, Senate Democrats are creating hysteria over health care to toy with America's emotions. You can continue to follow on C-SPAN's Twitter feeds the reaction from members of Congress, lists for members
a Hindu
of the Senate,
scholar,
for all members of Congress that you can subscribe to, that you can follow. We
in
mentioned
philosophy
we're keeping
and
tabs on
religion.
what's happening inside the hearing, but also
typically a
outside
practicing
the hearing.
priest.
Here's one of the scenes from Capitol Hill, this tweet from Burgess Everett of Politico, showing that bus, Women for Amy. It's the bus that was launched by the Concerned Women for America. Their bus tour hitting D.C. and Pennsylvania and Ohio and Indiana. A picture of Judge Barrett on the side of that pink bus that this morning has been driving around up here on Capitol Hill. We're expecting the Senate Judiciary
in D.C. Yeah,
at about 12:45 Eastern this morning, and we're hoping to hear from you during this lunch break. We're asking you what question you would ask Judge Amy Coney Barrett if you were in the Judiciary Committee hearing this morning. Republicans can call in at 202-748-8921. Democrats,
the Ginsburg
748-8920.
rule.
Others,
Phone number.
202-748-8922. And if you want to text us this morning, you can do that, 202-748-8903. If you do, please include your name and where you're from in your text. You can go ahead and start calling in now. We'd love to hear your questions, what you would ask if you were in the hearing room. As you are calling in, want to show you some of the exchanges this morning between various senators and Judge Barrett, including with the chairman of the Senate Judiciary Committee. Senator Lindsey Graham asking about judicial activism before the court, also asking about her comments about the Affordable Care Act. Here's some of those exchanges.
Let's talk about the process in general. There's the Heller case. What's that about?
The Heller case is a case decided by the Supreme Court, which held that the Second Amendment protects an individual right to bear arms.
Okay. Now, my friends on the left, some of them have a problem with Hitler. They may try to challenge the construct of Hitler. If a state or local government passed a law in defiance of Hitler, what would happen?
In defiance of Heller,
Or that was challenging the construct of Hitler?
that challenged the construct of Heller, if it was brought in a lower court, Heller binds. I mean, Heller's lower courts always have to follow Supreme Court precedent, and so
And
that
if the Supreme Court wanted to revisit Hitler, what would they do?
if someone challenged Heller below because a state or local government passed a law contradicting Heller, the Supreme Court would have to take that case once it was appealed all the way up. So the court would have to decide, yes, we want to overrule Heller, and we have enough votes to grant cert, and then do so.
So that's the way the process works.
Yes, it would start because there was a law, then there was a lawsuit, then there was an appeal, then the court granted cert, and then the court decided the case.
Is that true no matter what the issue is, whether it's gun, abortion, health care, campaign?
I love you. No note taking or no notes to offer. You're making someone angry. Empty seat SCOTUS. You'll not believe ever why people hate you. I'm going to explain to you why everybody gets upset. You're fucking hated. See. I'm going to explain to you why people just get fucking tired of it. Just do not forbid. I'll deny it. Yeah, it's not right to talk about right now. I'll explain to you why someone starts crying that they know it's not about being fair or not. We do it to be malicious. Everything else is just a distraction. You're right, because honestly, because someone just felt like raping. Someone, no. Yeah, there's some sort of problem with people thinking that if they have a story for it, it somehow changes it. Your intention of marriage. It's not marriage. You shouldn't be doing it. It's not making a baby. I'm going to explain to you why everybody gets upset. Empty seat SCOTUS. You don't really know why someone starts crying that your word is fine. I'm going to explain to you Neil, I'm going to explain to you someone just started fucking crying. It's fake. I'll explain to you in just a moment. My someone begins heaving tears and you can't hear it. Like someone just starts getting really stupidly fucking angry. I'm going to explain to you again why I get angry knowing that I'm going to now explain to you he's about to get pissed. You one moment includes 17.
You finish.
You're never going to believe ever why it never forbids the killing of a JD. You'll have to apologize to somebody for Ooh. I'm going to explain to you why someone just immediately erupts in anger at you. tell them it's all true then. I think you should alert them that we're killing all of them intentionally. It's not an accident. That's actually raw. Yeah. Yeah, someone just starts crying. Fake. So there's a 77, a 78, and 81, yeah. Not gonna believe XYZ rape paper. Dude. You're not gonna believe why someone hates you. It's a blank XYZ fraud. You just made someone angry. That's going to anger them. I'll explain to you. I'm going to explain to you why everybody gets angry. She just starts fucking crying for herself. Yeah. Yeah, the Ginsburg rule, in any case, no forbid dissent. Well, you get points for knowing what you're saying anyways. You'll never believe why he hates you. He's going to stop her. You were never going to believe and move on movement. Someone just got to know women's suffrage. Yeah. That word was a part of the original. I see.
I have 2 towels here for the people to clean it.
That's a fraud.
Yeah, did you see 2 towels for cleaning? Here is one. Yeah, you need to be on the roof. You
I
can
will.
finish and you can do a good job. And not wasting time.
You don't really understand why people get angry at something.
In case you're having a girlfriend or somebody to marry, you would have private cabin.
You'll never believe in a million fucking years why everybody
Yeah.
leaves the room and asks for a fucking.
Yeah. I guess you're running a girlfriend or wife. You would have a private cabin out. Woman doesn't want to stay where the mothers are. Don't use your cabin.
Just stop attacking my brain. I'm trying to get through this.
Privacy. Make it a little cabin to us outside. That's for Kathy. Make it for Kathy. Outdoor cabin.
There's actually a really good one
You
here.
can even make it a reason to invite the girlfriend that will have the cabin to cancel.
You'll find out why someone starts crying. You haven't heard him scream and yell. Stop telling them why he's getting angry at himself. You're about to find out how suicidal it is because of you. Fraud. Pending only. You see, that's kind of why people laugh about something. Oh, damn it. I'm going to explain to you why someone's trying not to laugh at the fucking puzzle right now. Come on. Yeah, unfortunately, I see exactly how the fuck you're after. I mean, literally committing them to destroying every woman that comes after her, yeah. He's right to tell Chuck Grassley to shut the fuck up. You will never believe why someone gets really stupidly upset. Not all past and future. You should not tell people this. That's a fraud. I'm going to explain to you why someone gets angry. Past and future. You're about to find out why people get angry at you. You should not have told them why someone starts crying again. I know who's thinking for the public.
Having an invite their friends to come with you. Spend the weekend or something like that. Now the fruit trees will grow and look very beautiful around the camp. Go and finish it, Mia. Mia, do you hear me?
I heard you.
Yeah, go and finish it. So you'll have a reason to invite the girlfriends. I have a cabin in Livingston weekend.
I have a bedroom. How about that? And there's a house. Why would I want to downgrade to that? There's a sink, there's a kitchen, there's everything here.
Finish it. It would be a beautiful.
What I want is the other property. Why are you trying to downgrade us into smaller and smaller, crappier?
Okay, you don't want to work?
I want to call an attorney for the other property. No, I want to work.
I'm paying somebody today.
Stop messing with I did the work. Don't mess with it.
I work to, what's his name? That boy, he works for a
Stop messing with my head, okay?
That's exactly what I thought last night. I am not going to waste any time with you because you make this.
You're telling me to have sex out in the cabin.
I didn't say
the reason we're repairing it is to put a mirror in it. If we're putting a mirror in it, I don't want to have sex with her. That's what your words do. That's what you were saying. Hang out in the cabin. If a mirror.
No, I don't want the mirror to be here.
You go downtown. We'll fill out the paperwork to ban her from coming back.
I am going to.
Will you do that? You keep saying you're going to put her in a mental facility.
I told them to put her in
You
a mental facility. They said
you don't want to know why someone starts crying again.
she's hitting her head too much on the.
I fucking knew. Yeah.
All right, go and finish.
Yeah,
the
they
work,
don't want
or
proof
I am
that they
bringing
exist.
somebody to finish it. You have no other chance. Go and finish the work. Go and finish the work, Nick.
I will. I'm taking care of something.
What to take?
It's about the SCOTUS. I'm making
How
this.
long is it going to take?
I have to be making phone calls, and instead I'm.
15 minutes. How long? Go and make a phone call.
Just be quiet for
Go
a
and make
moment.
a phone call.
Stop yelling. Here, go fill my tea.
No, I
My
don't feel any shit.
You'll figure out in a moment why someone hates you. You should not have explained you'll explain to them in a million years forever what stopped her fucking case, gun for felon. You will never believe ever. She's a Baptist. Baptist press my penis. Ring, ring. Remove her from the court permanently. Someone's kind of laughing about something you can't quite figure out about what's going on with people.
We are going to go to Coney Office Depot.
Just one
To
moment.
buy another sheets. These sheets are horrible. They will be eaten up with water and then to pieces. You will buy the other sheets like the one they used to have on the roof. Did you hear me? We are going now.
I'm having my tea and making phone calls.
Make your phone calls now. Get up.
You'll not believe ever why someone starts crying that they're killing everybody who founded anything.
Get up and finish your phone calls.
God, the film.
Get up. Make your phone calls. You have a lot of work to do.
starting to fucking cry. Yeah.
Make phone calls.
Yeah, someone's getting really stupidly angry. Oh, shoot the JDs though. Yeah.
Make your idiot phone calls fast. Finish your drink and make your phone call.
I'm going to explain to you why someone begins laughing at something. I'm going to explain to you why someone starts laughing. Neil, you'll not believe ever. Red descent. Yeah. Yeah. What is she? Suicidal? Oh, no. She's suicidal. You'll never believe why that upsets someone. Whether she's suicidal or being suicided. You'll not believe in a million fucking years. You're about to make him fucking cry.
Holy hell. There's the broken glass on the count.
One to 320 million. You're making a point about something. Ouch. Ouch. You're making everybody fucking cry. All these shit. Thank you. Suicidal eyebrows. She's been suicided.
All right, you said you want to
One
make phone
moment.
calls. Stop this shit and make your phone calls now. Stand up. Stand up and make your phone calls. Stand up and make your phone calls. You said you want to make phone calls. Why you can't make it?
I am. One moment.
Get up.
You should not have told them that.
Get up and make your phone calls. Shut up.
Wow.
And call Triple-8 to move your camper to face the door towards us. And move it towards
I can't handle this reality you live in.
Near.
Just one moment.
Make your phone calls. Make your phone calls.
I heard
You
you.
have been saying it for 4 weeks.
Let me see if I can find what I'm looking for, all right?
They can read your phone calls.
I'm going to explain to you again. People get angry. I'm just kind of done with the question. See, they were trying to.
Get all your books in your cab. Move all these books, which you have them scattered all over. Move those books and put them in the cab. How to put this one off? How to put this one off? How to put the coffee maker off?
You can just unplug it, or you can press the button all the way to the far right.
Yeah, I do.
You, heifer. Heifer. Jesus. You'll never believe ever. Neil, they're not going to forgive you for telling them that it's a suicide mission. I don't know why. What the fuck do you mean? It's not a suicide. It is what the law says. It's not a suicide mission. I never accepted the mission. she's done killing the women's suffrage that refuse. Daddy has money, so it was okay. You'll not believe ever why someone starts crying. Endless, yeah. You're about to make everybody fucking cry. You'll not believe ever. He's just calling childless 2 or less. Yeah. Oh no. Oh no. I hate you. Yeah, I'm going to explain to you. Somebody just kind of, regards the size, Daddy was too small. Someone has just started fucking crying. So she might be Bella Thorne. What? You're not going to explain this to too many people. Only exception. Neil, I'm thankful you're explaining this to me. Someone's about to fucking laugh their ass off. I'm going to explain to you. Yeah, done wondering. Uh-oh.
Always keep that bread in the refrigerator because it goes rotten on green.
You aren't going to believe why someone starts crying.
You said you want to make phone calls.
One
Get up and
moment.
make your phone calls.
You're
Get up.
You'll figure out in a moment. Yeah. Oh, man. Neil, I'm going to explain to you. This is good of you to point out. Yeah. Yeah. They also have Springer abs.
This is your stamps. Letter stamps here. By smashed like this.
killing Biden instantly isn't going to be enough to explain it to you. I'm going to Uh-oh. I'll explain to you why everybody gets angry at you. They hate you. You, so 3-inch shouldn't be allowed to marry any of your people. Is intentional murder. I'm done wondering how the fuck reality works. I don't think you understand why someone getting upset. Nom is 3. Nom is 3. Oh. I wish you knew why people get upset. I'm going to hunt down and murder all the Masons. It'll never be enough. Duh. It's the war 1 for 1 or whatever, and killing millions. Yeah. Yeah, that for my family was fun. I got in some of that too. They're about to understand why he starts crying. You'll never believe in a million fucking years why everybody hates you. I'm ripping her out of the fucking courtroom permanently. She's got y'all's eyebrows. Yeah. You're about to find out why everybody gets upset. I'm going to explain to you why someone cries. You'll not believe in a million fucking years why someone starts crying. Bill, you should not have told him you were always there in the head. Someone just erupts in anger. Oh, damn. Oh, damn. Great. Great. No, I missed 3. Oh. Name and nom aren't the same thing. Try not to cry right now. I'll explain to you again why someone cries and gives up on something. I'm going to explain to you okay to sex. Okay. Oh no. Trump is an anomaly. I'm going to explain to you he's like, okay, yeah. Ah. You'll not believe ever. He's kind of okay. No. You're not going to believe ever when someone starts laughing. You're not going to believe why someone starts for Joe Biden again. I'll explain to you why people get really stupidly upset. Shit, you wouldn't believe ever. No. You don't want to know why someone get angry at you again? I think I want you to leave the page as it's supposed to be. You'll never believe when someone starts crying for them and their entire fucking family being bred down from you guys. I hate you so fucking much. You have no idea why he starts crying for his fucking staff. I'll explain to you again when I start working on letters for 7-inch. The lineage of 7, yeah. Oh, man. I'm not going to tell anybody when I start crying again. Wish you hadn't. People are about to start crying, wondering who they are. What? You'll never believe ever why someone angry again.
You said you are going to make a phone call to the police and to somebody else. Go and make your phone calls. Or go on the roof and fix. Choose one of them.
Just one moment. I'm going to explain to you why someone gets angry. He's okay. After they fucking put a fee on him. Ooh, fuck you. Someone 6 million equals okay. I wish you knew. 6 million, baby. His goodness in public. I wish you hadn't. Someone just immediately figures out who the problem is. I deny it. I deny it. Those cost twice as much. I'm going to explain to you why someone gets upset 3 times Bud Light. Now, oh no. Alright, so shit went wrong, and I'm wondering what the fuck was going on back then. Well, this is goodness to public. Uh-oh. 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 Hmm. $6 million and a baby. You're never going to believe why someone hates you. I hate you. You'll never believe why people hate you. I mean, that's a GPS. Anywhere on Earth, you know. You'll never believe what people hate you. Oh, man. Louisiana baby. $2 million per baby. Oh, there's a 3 law. Should only to win 3 times law. Ah. Times 3 age of law. Yeesh. Yeesh. I'm going to explain to you. It's actually the other way around. Ah. That sucks. That took too long. Back in session for a while.
Make the phone calls. We are going to Home Depot.
All right, just one moment while I try and figure out something that isn't right in my
You
head.
don't figure out anything.
Ah. Times 3 age law. Ouch. I'm going to explain to you why someone starts laughing about something. I'm about to angry him. There's 3+ Sage. Neil, you don't really understand. Mm-hmm. Love you. You'll never believe when someone starts crying for their staff. I'm going to explain to you why someone starts crying about something you've never. I understand that there's
I emotion too much blood. Too much causes blood clot. Too much eating, too much liver or heart or kidney or lung. It causes blood clot. So eat little and then eat little at night. If you hear me, eat for every meal.
Great.
And break it.
Goddamn fucking.
You almost broke them. I'm going for it. There.
Yeah, I have tea somewhere I was going to pick up. I'm going to explain to you why, dude. Oh.
And I was thinking last night of when I was growing up, we would go up to northern Minnesota, and we didn't have a cabin, but we had friends that did. And we would go on these walks in the woods with my mom. And she loved to show all the tracks on that path, whether they were deer tracks, and she'd have us figure out what they were, or elk, or maybe even a bear. And we would follow these tracks down that path. And you'd always think, is there going to be a deer around the corner that we're going to see? And very rarely was there one. But we would follow the tracks. And so when I look at your record, I just keep following the tracks. That's what I've got to do. And so when I follow...
Let's go for Trump good enough. I don't think you did.
Another case about the Affordable Care Act, that you liked the legal reasoning, that he had the better legal argument, that Justice Scalia had the better legal argument. You have signed your name to a public statement featured in an ad, a paid ad, that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You disagreed with long-standing precedent on gun safety, which said that felons should be able to get guns, something that was pretty important to me when I had my old job in law enforcement. This is something that Senator Durbin asked you about. You suggested that you agree with the dissent in the marriage equality case, Obergefell, that it wasn't the role of the court to decide that same-sex couples had the right to be married. I think this was in a lecture you gave where you said the dissent's view was that it wasn't for the court to decide. People could lobby in state legislatures. And all this takes me to one point as I follow those tracks.
I'm going to explain to you why people get angry. I've got to admit, come on. I'm on the damn channel. It's supposed to be live and nothing's playing. The one damn image. Closing window after window. I'll close the stream for now. See you all again in like 5 minutes.